We often see a daughter-in-law filing a case against her mother-in-law. But have you ever heard of a mother-in-law filing a case against her daughter-in-law? Earlier, domestic violence cases were filed only against men. But now the law has changed. If the daughter-in-law commit any act of violence against her mother-in-law, the mother-in-law also has the full rights to file a case against her. Under the Protection of Women from Domestic Violence Act 2005, a mother-in-law can also file a case against her daughter-in-law. Section 2 of the Domestic Violence Act defines an aggrieved person to mean any woman who is or has been in a domestic relationship with the respondent and who alleged to have been subjected to any act of domestic violence by the respondent. So, an aggrieved person include women, daughter-in-law, mother-in-law, sister-in-law, and any widow or any female relative living in a shared household who faces domestic abuse. Therefore, if a mother-in-law suffers verbal abuse, harassment or physical harm from a daughter-in-law in a shared household can file a case. The domestic violence is not just physical. It includes physical abuse, verbal abuse, sexual abuse, any unwelcome sexual behavior, emotional abuse. Emotional abuse include insult, harassment or humiliation, even threats and harassment affecting health, dignity and mental well-being count. NRIs and family members can file a domestic violence case even if violence is occurred in India. If the aggrieved mother-in-law is in India, she can file the case under Protection of Women from Domestic Violence Act 2005. If the daughter-in-law live in abroad, subject to survive of notice and legal representation, court may coordinate with foreign jurisdiction under mutual legal assistance treaties if cross-border enforcement is needed. For example, if mother-in-law is in India and daughter-in-law live in abroad with her husband, then if daughter-in-law abuse her mother-in-law from abroad by any kind of reason like threaten or using abuse language, then how mother-in-law can file a domestic violence case against her daughter-in-law? Let me explain the step-by-step process. First, identify the offense. If the daughter-in-law abuses, threatens and humiliates the mother-in-law even by video calls, messages or emails, causes mental harassment and defamation, uses offensive languages and false allegations, then it may amount to domestic violence, Section 3 of Domestic Violence Act, or criminal intimidation and insult under the Bharatiya Nyaya Sanhita Section 351 and 79. Even though a daughter-in-law live in abroad, the mother-in-law can file the case in India because the aggrieved person resides in India and the act of harassment was felt in India. Mental harassment by calls and messages is enough. File a complaint, go to the nearest police station or the protection officer under Domestic Violence Act or the magistrate court directly. Prepare a written complaint describing the abusive behavior. Mode of communication like messages or calls. Any evidences like screenshots, messages or any other witness. The complaint should name the daughter-in-law as respondent under Section 2 Clause Q of the Domestic Violence Act. So here are additional legal remedies. The mother-in-law can file a criminal complaint under 351 of Section Bharatiya Nyaya Sanhita for insulting or abusing gesture or criminal intimidation under Section 79 of Bharatiya Nyaya Sanhita. So what are the documents needed for filing a complaint? ID proof of the mother-in-law, evidence of relationship, proves that daughter-in-law is married to her son, copies, screenshots of abusive messages and calls, witness statements, if any she have. Even if the daughter-in-law is in abroad, the court have the jurisdiction because victim mother-in-law is in India. The Ministry of External Affairs and Indian embassies can help in serving notices abroad. Interpol and Red Corner notice can be issued if case escalates if she ignored the court summons. In the case of Garima Gupta versus State of UP, the Allahabad High Court observed that the Protection of Women from Domestic Violence Act 2005 is a beneficial legislation aimed at to protecting women from domestic violence. The court emphasized that the definition of aggrieved person under the Act is not limited and includes any woman who has been subjected to domestic violence, irrespective of her relationship with the respondent. Therefore, a mother-in-law can be considered an aggrieved person and can file a domestic violence case against her daughter-in-law if she has been subjected to domestic violence. At last, a mother-in-law is legally recognized as an aggrieved person under Protection of Domestic Violence Act 2005, and she can file a domestic violence case against her daughter-in-law for physical, verbal and emotional abuse. The same law applies to NRIs, provided the incident occurred in India and affect the property rights in India. If you found this video useful, don't forget to like, share and subscribe NRI Legal World.